Hi, I'm Neil Janal, and I just gave a speech to the Jewish Community Foundation about estate planning and property taxes, specifically Proposition 13, which is the property tax regime in California. Both areas of the law are somewhat confusing, and to make the speech even easier, both areas of the law have cross tensions and work in kind of opposite directions. As many of you know, in estate planning, one of the main goals is estate tax minimization, and you accomplish that goal by transferring your assets, including California real property, to your children or other intended beneficiaries. As well, you want to plan for your own disability, so you will transfer your assets to a revocable living trust so that if you lose capacity, the person you name can manage those assets without going to court. And that's pretty much the tried and true estate planner's regime, is transfer assets from the individual's name to ever more increasing complex structures. With property taxes, it's the exact opposite. Every transfer of California real property can cause what is known as a change in ownership, or a CIO. A CIO can result in an increased property tax bill. So when you come to your estate planning attorney, he will likely suggest all these wonderful property transfers of your real property to save the estate tax. Unbeknownst to you, hopefully not unbeknownst to him or her, those transfers could cause a property tax bill increase that could go on forever. And the way the law works is the property tax law has incorporated numerous exceptions to the basic rule that when you transfer a property in California, the assessed value, which is the basis of your tax bill, a tax bill is equal to 1% of the assessed value. That assessed value is increased, which is usually the case in a rising market, from its assessed value to its fair market value. So if you have a home which you bought for $300,000, which is now worth $1 million, if you transfer it to somebody, for example, in a sale, the tax bill goes up from your $3,000 tax bill to $10,000. That's bad enough when somebody you don't know inherits that new tax bill, but when your loved ones get this new tax bill because you didn't take advantage of the numerous exceptions, it's even worse. And what we've discussed today and what people have had questions about is one of the new quirks in property taxes is properties have actually gone down in value. So you may actually want to cause a reassessment. For example, if you have a home that you bought for $1 million and you want to transfer it to your children, which is usually an exclusion from reassessment, but now it's only worth $600,000 and you bought it for $1 million, so your assessed value is $1 million. But if you give it to your children and do not claim the parent-child property tax exemption, the property's assessed value will fall to $600,000. The tax bill goes down from $10,000 to $6,000. You've just saved $4,000 a year. So to make it even more confusing, the normal rules of estate planning and property tax planning have been almost turned on their head by the current decline in the California real estate market. However, brighter times are ahead, and the normal rules and the normal exceptions should apply. One of the more interesting techniques we discussed today was what's known as a family limited partnership or limited liability company. You've certainly heard about these structures, which are used for estate tax minimization, because by putting in your real property into these entities, all of a sudden, almost magically, they become worth less than they were outside of the entity. If you give away 10% of an LLC that owns an apartment building, the value of the gift is worth less than 10% of the full value, because what you are giving to your children or other recipient is 10% of an entity, and something you can't sell. You can't go out and sell a 10% interest in a family entity. Even if you have a wonderful family, nobody wants to be in business with a stranger in a minority interest that's not really marketable. So that is a main staple of estate planning, and what we discussed today is that for property tax purposes, when you go into one of these limited liability companies, there's a right way to go into it. You have to certainly have your children own a part of the building, then go into the limited liability company, which the children own in those same percentages along with you. And then once you are in this limited liability company, the transfers you make for the estate planning purposes are capped at a certain percentage, no more than 50% from the day you went in. And there are lots of questions to be asked. It is a very interesting field to those who are interested in it, and I encourage you to read up on the materials, and if you have any questions, consult your advisor. Thank you very much.